Good morning, everyone, and welcome to this webinar organized by the Spain-US Chamber of Commerce in collaboration with Quabbala. For those who are not familiar with Quabbala, they are a law firm specialized in corporate, individuals, and M&As. They also have Rubén García as a managing partner specialized in bankruptcy. And today we also have with us Shirley Palumbo, that will be also speaking about bankruptcy. Good morning, Shirley.
Good morning. How are you, Gabriel?
Good. How are you?
Excellent. Thank you. Thank you, everybody, for having us today to talk to you about bankruptcy and insolvency procedures, especially for small businesses. Rubén, I see you.
Hi. Good morning,
Okay.
Rubén.
Good morning to you.
Yeah, he's the managing partner of Quabbala. He's an economist with a master in European law, economics, and informatics. Since 1988, he's the managing partner, and he's a specialist in commercial, corporate, and bankruptcy law. He also acts as trustee in Spain since 2007 and in London since 2012. He's an expert in companies in the Asian market and has developed his professional life in different positions of responsibility in Asia, Europe, and America. On the other side, Shirley is the Bankruptcy and Insolvency Senior Counsel in West Palm Beach office of Greenspoon Marder. She has an extensive experience in bankruptcy, debt restructuring, and insolvency. She's a member of the Florida Bar as well as the Puerto Rico Bar, and she's admitted in the 11th Circuit Court of Appeals. She's board certified in consumer bankruptcy law by the American Board of Certification and has been recognized with the Martindale-Hubbell's highest ranking in both ability and ethical standards. She has an LLM in international law from the University of Miami, as well as a JD from St. Thomas. Before our panelists start their presentation, we wanted to remember our attendees that they can ask questions on the right panel on their screens, and that we will send a follow-up email that will include the video of today's session, the presentation, and the contact information of the panelists, so everyone may contact them after. Now, Shirley, let me please unmute.
Very well. Do you see the PowerPoint presentation? Can you see it?
Yes, we do.
I'm gonna get.
Yes.
Okay, very good.
Yes.
So I'm gonna get started. So here we are. I'm gonna be talking to you about bankruptcy and insolvency procedures right here in the United States, specifically with Florida. But as you know very well, bankruptcy and insolvency in the United States is a federal law, so it's applicable to any state at this point. So if you decide that you have a business here, but that you also have a house in New York, these are issues that may be talked about later on, but that they're definitely going to be applicable to what we're going to be speaking today. Now, today, I'm going to be speaking from the very, very, very basic 101 bankruptcy, just because I am not familiar with you and I am not sure of how much of bankruptcy law do you know. So if we get started, I'm going to start by the most basic part, which is an overview of the bankruptcy process in the United States. And in the United States, you have a bankruptcy basically composed of three parties. There's different three parties. There's the debtor, there's the creditor, and then there's the trustee. As you know very well, the debtor is the person that owes the money. It's the entity that owes the money, and the creditor is the person that is collecting the money. So it is the company that wants that money that hasn't been received. When you file for bankruptcy, you're basically telling the world, wait a second, I can't pay anymore. At this point, I am tight and I cannot do it. And because I cannot do it, I need the assistance of the federal system, and the federal court will come in. Now, why is that important? That's very important to know because under the system that we live in, the creditors have the right under state law. So I have the right as a creditor to collect on you under Florida law. And I have the right to go ahead and foreclose or repossess or file or garnish pay stub, whatever it is, I can do it under state law. So it is the federal law that comes in and protects that entity from the state system and says stop, which is what we call the automatic stay. So we stop and we say this person cannot continue being collected on, and we need to proceed in bankruptcy as a protection. It is also very important because if you do come from Spain or if you do businesses in Spain, and you look at the history of the bankruptcy, it's looked at something bad. It's looked at something that it's not good to do. But in reality and in practice, welcome to the modern world. It is actually a very, very good negotiation skill. It's something that needs to be done a lot of times, and it's something that you need to, most of the time, be able to do in order to restructure your business and improve your business from now on. So I want you to consider this as a positive thing for your life. So what happens when you go to bankruptcy? You have the parties, like I told you, debtors, creditors, and trustees, and you file immediately a petition. It's a little package which gives the world the income of the company, the expenses of the company, the type of debts that we're talking about. Are we talking about security loans? Are we talking about mortgages? Are we talking about leases? Are we talking about letter of credit? All those type of debts need to be included in the bankruptcy. You cannot prefer to do one but not to do the other. You cannot choose. You just have to include them all. They're going to the pool of the bankruptcy estate. And after that, you basically put as well all of your assets. And in your assets, you need to put everything. Do you own any real estate? Do you own any vehicles? Do you own any tractors? What's your accounts receivable? All of that is going to be considered as part of your assets. When you go to the bankruptcy, you're going to go through the trustee, and the trustee is going to ask some questions exactly verbatim, consistent to what you have given in the package, which is, well, who are you? Why did you file for bankruptcy? Have you included all your income? Have you included all your assets? What's going on? That is called the 341 meeting of creditors. It's very interesting because very rarely creditors appear at that meeting, and the meeting is pretty much conducted between the debtor and the trustee. The trustee is there to basically administer the money. So it's going to be an estate, and it's going to be the creditor that is owed money to, the debtor that owes the money, and then the trustee that wants to collect any money that the debtor can give them. Within that type of money, it can be through the assets that can be sold through a bankruptcy, or it can be from money that the debtor has that can offer and says, this is all I have. And then it gets disbursed between the creditors, but we don't have to talk about that now. Basically, it goes through the process of administering the funds. And once the funds are administered, the bankruptcy finally either gets closed and you receive what is called a discharge of all your debts, or it gets converted into any other type of bankruptcy, because it can happen. There's different types of bankruptcy, and you can convert them into different ones if the one that you started with really is not applicable to your situation, or the case can get dismissed. Ultimately, once everything finalizes, the case is closed. And if there's any creditor, if you're a creditor and you're owed money to, and you believe that there's some type of fraud involved, and it could be either a fraud or maybe you're a spouse, and this person, the former spouse, the company files for bankruptcy. She thinks she's owed money to. She is a creditor of that bankruptcy, and they may end up having to file legal lawsuits within the bankruptcy process, and those lawsuits are called adversary proceedings or contested matter. I'm going to switch the slide, and we're going to talk about the automatic stay. The automatic stay is basically what I told you. It's just stop. Everything's frozen, and nobody can collect on this debtor. Nobody can foreclose. Nobody can file the lawsuit or continue with the lawsuit. Everything freezes at that point. If somebody tries to continue or somehow believe that they're entitled or that nobody's going to know, it's known. It's called automatic for a reason. It comes back to bite you, and it's really sanctionable in court. It looked very, very bad, both under the federal and under the state system. So there's different types of bankruptcies. But the most important part that I want you to know is that in bankruptcy, when you put all your assets, that includes everything. That includes your shares in a company. That includes your real estate. That includes if it's an individual bankruptcy, for example, it would include inheritance, an inheritance portion, even if it's a portion. So everything will be there. Of course, there's going to be some laws that we can apply that protect some kind of real estate. Those are exemptions. The exemptions are usually applicable to individuals because companies do not have exemptions, and companies do not receive actually a discharge. But I'm going to talk about that very soon, depending on the types of bankruptcy. It's very important because with all of those assets, once you're in the bankruptcy, whether it is through a trustee or whether it is through you, you're going to have to determine what to do with all this property. Can you keep the property? Do you need to sell the property? Can you get rid of the property? Can you use the property, i.e., can you assign it? Can you lease it? All those things are things that you can consider once you file for bankruptcy. Now, the important part for us is the types of bankruptcies that we have in the United States. And in the United States, we have quite a few, and the most interesting one is going to be the small business one that I really want to talk to you about because it's brand new, brand new, literally. It came into law on February. But let's just start with the basics, which is your Chapter 7. So why are they called chapters? They're called chapter because it's a bankruptcy code. It's like the bankruptcy Bible, right? And in the bankruptcy code, you have different, just like every book, it has a different chapter. And you can have a Chapter 1, which is all about definitions and acronyms. And then you're going to have a Chapter 3, which is all about the duties of trustees. And then you have your Chapter 7. Your Chapter 7 is a type of bankruptcy where you decide that you want to close your doors of your business, or if you are a person where you want to completely turn around, not pay a penny if you can, and say goodbye, see you later. This didn't work out. That happens usually in new businesses, for example, that have been around for less than 5 years and they didn't work out. Happens a lot with tiny businesses like Pilates or gyms that open and close their doors, but they have this a lot of equipment that they leased or a lot of money that they owe money to. Happens with subcontractors. Happen with small restaurants that have refrigerators and a lot of equipment that has been either leased or mortgaged. And they just want to close their doors and forget about everything. You can liquidate through Chapter 7. Under Chapter 7, you have the statement of intention and a reaffirmation. And under that statement of intention, you basically let the world know what you're going to do with your assets. So that if there's an asset that is collateralized, you can say, I am going to pay this secure creditor in exchange of this equipment, or I'm going to pay this secure creditor in exchange of this furniture, or I'm going to keep paying the mortgage and be able to stay with this building. In order to do that, however, you want to ensure that you are current with that particular debt. Now, that doesn't mean let me pay and then file for bankruptcy. That means you're going to have to talk to an attorney so that you're not committing a potential fraud, but that you're actually understanding how to administer your company's estate when you file for bankruptcy. So you want to be very, very well aware that you can do that, but that there's ways to do things. And that happens in the Chapter 7 liquidation. So remember, it's a closed door. However, you can actually pick and say, I'm going to stay with this. I am current with this, and this is something that I need in order to be able to continue with my life. We have Chapter 9, bankruptcies. That's for municipalities. It's not applicable to any of us. It would be applicable to, for example, the city of Miami-Dade. I don't know if you remember many years ago, Miami-Dade did go through some kind of restructuring. It has happened. We have tried to apply those laws to Puerto Rico under a new congressional frame. We try to apply those municipalities law into a state. There's no state or sovereign chapters, but those were the ones that are most consistent, that are applicable to that. We don't talk about that here. We talk about Chapter 11. Chapter 11s are very, very, very important. Those are the type of bankruptcies where you're able to stay in control. Those are the ones, the type of bankruptcies that you encourage when you actually have either shares that have value, you have buildings, you have sufficient asset or sufficient income that you're able to strategize and be able to reorganize your business in order to start again. Under the Chapter 11, it's always been, there's no trustee. The only time that a trustee is involved is when there's either some kind of fraud or there's some kind of mismanagement of the company. And there we're talking about companies with board of directors, real active board of directors. We're talking about opportunities to go about and get rid of leases that you want to reject, or get rid of licenses that are not really producing anything, or get rid of a particular mortgage and surrender whatever that collateral is, because it turned out to be not a refrigerator you wanted to keep in your restaurant, for example. And that's where you take advantage. The Chapter 11 has no boundaries. Chapter 11 cases basically are the kind of bankruptcy where you go to your attorney and we kind of like strategize how we're going to do this. And it can take from 5 years to 30 years to put that company in a restructure where they can formulate and get out of these millions and millions of dollars of bad debt and be able to come up with new credit, obtain credit with new loans, and be able to continue their business. It's very important to know that, because in order to start a Chapter 11, you need funding, okay? If you don't have the funding, you might as well not think about Chapter 11. And the reason this is so important, it's because we ended up creating a small business, Chapter 11. And that's the one that is more amenable to what we have in real life. It's the laundromat. It's the restaurant we're talking about. It's the subcontractor or the contractor. Are those businesses that really, really, really consist of everyday life. And those businesses file for bankruptcy and they don't have millions and millions of dollars or big board of directors. Sometimes you're it. It's one sole shareholder. Sometimes it's two. And most of the time you have the funds, but you're talking about, a few $1 million in debt, and that's it. Or maybe you're talking about only $250,000 in debt. That's the kind of business we're talking about here. It's small. It can be $10,000. It can be $7 million. And you will fit in that type of bankruptcy. And we're going to get into that with details. We have the Chapter 12, which is for fishermen and farmers. And under that type of bankruptcy, it's a lot. You usually see, I've seen them, and I practiced them in Fort Myers, in this part of the west side of Florida. And I've also overseen, because that's what I do. I manage throughout the whole nation bankruptcy proceedings. And I have overseen Chapter 12 basically in Iowa, Wisconsin, Midwestern communities and states. So that's where you would see your Chapter 12. I don't think you're going to see them in our area. But it's there for you to know. Chapter 13, it's very interesting. And the reason I put it there is because Chapter 13 is a reorganization like Chapter 11, but it's a reorganization for an individual that has a regular income. Why do I put it? Because a lot of times I've had situations where I have a sole proprietor that has 3 or 4 warehouses. They're mortgaged. So it's his business, but he doesn't fit into a Chapter 11 or into a small business because really it's his person that is being liable to the world. And in that case, there's a cap of 379,000 in unsecured and $1 million, something like 1,500,000 at this point. Every year it changes unsecured debt. But if you fit into the eligibility of a Chapter 13, you can be your own business and still file a personal bankruptcy. That exists. That has to be done in 5 years. In 5 years, you would have to finish it. It can be taught. It's based on disposable income. You redesign your life, and you're able to acquire a discharge of your debt. And Chapter 15 is a chapter. Essentially, it's a cross-border. So we have the United States, and we have Spain, and we have a company, for example, that will file in Spain with Rubén. That's gonna let you know soon how to do it. So they file in Spain, but for X or Y reason, they have assets in the United States. You could have shares in the United States. You could have buildings in the United States. You could have a subsidiary in the United States. For all those reasons, there may be a trustee in Spain, or there may be a creditor in Spain, or maybe you want to be able to better administer what is going to happen in this side of the world. That's where Chapter 15 comes in. Chapter 15 would immediately allow a person from Spain to represent as a foreign representative of that bankruptcy in the United States and be able to knock on the United States doors and say, hey, I have business here that I need to take care of under a bankruptcy in Spain. Can I do it? And that's the process that would be applicable to it. We'll talk about that too. Moving on. And you let me know if you have any questions, I guess, at the end of the presentation. But let me just then keep going. Chapter 7. So Chapter 7, specifically, there is always a trustee. So it has nothing to do with fraud and risk management. You will always have a trustee. The purpose is liquidation. Liquidation means depleting all your assets, making them into money, and with that money be able to disperse to all your creditors. Everybody gets a distribution, a little bit for you, a little bit for you, a little bit for you, based on what the law tells them that they're entitled to. And then after that, basically it gets administered and it gets closed. Liens survive bankruptcy. So that's where you have to decide whether you want to stay with that lien and keep on making payments to it, to that particular creditor, or you want to surrender the collateral and stay without the lien, but without the collateral. You know, the creditor keeps it. An example of that is landlord security deposit, for example. You don't want to stay in the lease and you're a tenant for a landlord. You are able to reject that lease, but then the landlord will stay with the security deposit, because in Florida, the landlord is entitled to that landlord lien over the security deposit. Let's see what else is important for you to know. If it's a corporation that files a Chapter 7, they're basically closing the doors and not making any payments. Now, when is that important? That's usually important because you may think, well, if I just close the doors, why do I have to do a bankruptcy? I'm just closing the doors and that's the end of it. I have no money. Very true. But in the United States, welcome to supplemental discovery proceedings, which is a creditor can acquire a judgment. And after that judgment, they can still harass you through depositions, interrogatories, requests for admissions, execution in aid of judgment, and they will definitely try to see how much can they cut through your company and get to your person. And if that's the case, bankruptcy Chapter 7 is very important for that company that has already closed their business. They're still being harassed. They're still trying to figure out how to touch your mansion. And you're going to go ahead and turn around and file a Chapter 7 for that company. So that's where that one fits in. Moving on to Chapter 11, because it's applicable to us. And in Chapter 11, like I said, usually it's about large businesses. But it's very important to know that it's a reorganization of your business. But a lot of times, and it is actually the law allows it since 2005, you can do individual Chapter 11s. So, for example, in Nevada, overseeing a case in Nevada, I just had a bankruptcy where there were $65 million in a commodities business, and it was actually a contested divorce that forced the person to file the bankruptcy. And the bankruptcy that fit was a Chapter 11 case. So as you see, it's any debt will get you there. Under the Chapter 11, it can be an individual, it can be a company, but it's going to be for companies that do still have funding and that do still have the ability to restructure. And what you do there is like Trump. Remember Donald Trump and how everybody says, oh my God, he's filed like 7 bankruptcies. He was actually doing a good business. What he does is that he looks at all of his negotiations and says, I did a bad deal here. I did a bad deal here. This is a good deal. I'm staying with this one. And I need to renegotiate our deal together because I don't like this term. However, I'm willing to give you this in exchange. And under that Chapter 11, that's where you're able to strategize and come up with a plan in the first 4 months of filing the petition. After those 4 months, however, there's a couple of barriers, right? And some of the barriers is, for example, you have a competitive plan that can be filed against the debtor. So if you're a creditor and you wait quietly for 4 months, not quietly because you still have to file your claim and say, hey, I'm here and he owes me X amount of money. But if you're able to stay calm down, waiting to see what is going to be offered, and you see that there's no movement after 4 months and he hasn't filed a motion for extension, because they can do that too, then you can go ahead and propose a plan payment for the debtor, all right? Very interesting, and that's very important because sometimes you have big businesses with 10 creditors, not 500. And under those 10 creditors, you may very well be familiar with what that business as a creditor, what that business was up to, and say, well, guess what? I know you have a lease. Why don't you treat it like that? And my equipment, you're going to treat it like this. And you're going to create their own plan. So those are things that can be done in Chapter 11. However, Chapter 11 requires voting, solicitation of votes and voting, requires, like I said, you can lose your exclusivity of filing a plan payment. Chapter 11 can last all the way to, like I said, 30 years. And in a Chapter 11, the company does not receive a discharge, okay? So it's not goodbye, debt, see you later. It's basically pre-confirmation is forgiven, but post-confirmation, this is how we're being treated. And that's the end of that. So it's very, another thing that I want to mention is the operating reports. When you file for Chapter 11, you are required to every month to submit to not the trustee because there's no trustee, but to the U.S. trustee's office, which is running and administering all of the bankruptcy cases for the Department of Justice, okay? Which is a department that works with the FBI, so it's an important department to work with. And they want to see every month your monthly operating reports. How much is that business receiving? How much is that business spending? And how is that being spent? A lot of districts like in Florida, Southern District, for example, they will require the bank statements to be attached under a new credit, under new bank accounts that you have to open when you file a Chapter 11. So it has its own, oh, look, a little typo. It has its own barriers, but it can be done. And basically what I wanted you to know about Chapter 11 is that a lot of publicly traded business use it. There is no trustee, like I said, unless it's fraud or mismanaged. There's the exclusivity period that I told you. There's classes of claims. So for example, you may, as a debtor, decide, I have 3 mortgages and I'm going to put them all together and treat them all the same way. That's a class of claim. I have all of these credit cards. I'm going to put them all together and I'm only going to offer $10 a month. And that's a class of creditor. And that's why they talk about classes of creditors. But that's very important because those classes of creditors will have voting rights. And something magnificent about Chapter 11 is a Cramdown. And the Cramdown in a Chapter 11 is a different Cramdown from other type of chapters. It essentially means that you're going to be able to do is get all those solicitations and all those people to vote, but you can still have a plan accepted, approved, and confirmed, even if there's some classes of claims that have rejected the plan. So as a debtor, that's a huge benefit. There's, again, the details on how that comes about, but for all purposes, Cramdown is a feature of Chapter 11 and reorganizations that basically forces a secured creditor to accept the plan as is, even though they didn't like the plan after all. Okay, so that's that. Now, let's talk about the Chapter 5, which is the one that was enacted in February. So this is what happened. It was enacted in February at the end, 26, 2020. And by March 25, a month after, 4 weeks after, they amended that law. Why? Because of coronavirus. So when it was enacted where a debtor that has up to $2,725 in debt, not in income, in debt, they can file a Chapter 11 small business. And that has now changed to allow to expand the debt to $7,500,000. That's very, very important to know, because that means that more businesses are going to be able to squeeze into this type of bankruptcy. And the reason this bankruptcy is so beautiful is because there's no voting. There's no something called disclosure statement. It's expedited, it's streamlined. It's basically like saying a Chapter 13 or a Chapter 12, which are plans designed for 5-year repayments. And essentially the business can continue after all that. So it's really, really like get in, hammer it, get out, and you're a brand new entity. So it's really, really sought after. Basically, in that one, you're going to have your business is going to continue. It's applicable to almost anybody that has a company. You can be an attorney and file under that chapter. You can be a person that has a business in your own house. And if 50% of your house is being used for that company, for that business, off you go and you can file on this type of bankruptcy. You have a signs business and you have your equipment in your garage, and that's how you work. You can file for this bankruptcy. And you can have $7 million in debt and you can file for this bankruptcy. So see how everybody of everyday life can fit into this type of bankruptcy. Now, this bankruptcy is going to have a trustee. So you're still a debtor in possession like a Chapter 11, in the sense that you stay with your income, you stay with your assets, you design your plan payment, but there will be a trustee overseeing what you're doing, okay? But why is that? Because we're trying to get out of this bankruptcy in 5 years, and we don't want any problems, all right? So you're gonna streamline it. You're gonna have disposable income that is going to go through the plan. So that in Chapter 11, when you file for bankruptcy and you have your assets, you're able to obtain credit and manage these assets on your own. In a subchapter 5, you're going to have your assets, you're going to manage them, but then you're going to receive an income for yourself. Well, that income is part and probably one of the majority of the ways that you're going to introduce into your plan payment to be able to pay not all your income, after your expenses. So after your expenses, you have $5,000 worth of monthly income. Those $5,000 are going to be added to your plan payment. So $5,000 every month for 60 months is going to get you into a repayment plan where you say, okay, I paid you what I could pay you, goodbye, see you later, and you get out of it with a brand new company. That's really what they're trying to do. Everything else that I'm not mentioning, it's legal things that you don't really need to know that basically were supposed to be done in Chapter 11 cases that I do not need to do in a subchapter 5. We're talking about things called like absolute priority rule, where there's a specific scheme of payment that I need to follow. We're talking about voting rights, like I told you. We're talking about Cramdown rights, like I told you. And another beautiful thing that this particular bankruptcy is able to do is that you can include your homestead, as long as, of course, it's being used for business, like we said. So if you have a mortgage there, you include that mortgage as well. And there's opportunity for strip off, which means pay zero to mortgages. So for a debtor, it's a very, very beautiful type of bankruptcy to have. Now, one thing I wanted to mention is that right now in coronavirus times, we're having a sort of like an argument that has not been resolved. And I need you to be aware of this because it's not resolved. It's that under the fabulous trillions of dollars that the United States, that Congress has provided under the PPP loan and grants, all those loans and grants, right now, if you file for bankruptcy and you try to you're in bankruptcy and you submit that application so that you can continue paying your employees, it will be denied. And that is very important because when you look at the law that Congress enacted, it doesn't say that it's not applicable when you file for bankruptcy. Yet, the Small Business Administration created the application where if you file for bankruptcy, it's being the application gets rejected. As of right now, there's various states like Texas, California. I believe there's some in the Midwest area that are coming up where the debtor's attorney has filed an injunction in the district courts and are enjoining the Small Business Administration from not being able to apply if you have filed for bankruptcy. So that's something that right now I wouldn't suggest file bankruptcy and you're still able to go through those grants. But and another question we have is, well, can you apply for the grants and then file for bankruptcy? Right now, there's no law that says you cannot do that. There is a law called preference. A preference is viewed as a fraud, where the person that files for bankruptcy will go ahead and either repay someone with a previous 90 days prior to the filing of the bankruptcy, and then go ahead and file bankruptcy. That person preferred that creditor over another, and that person will be viewed with bad eyes, and that money will have to be returned into the estate. However, there's nothing saying that you cannot accept a grant and then be able to file for bankruptcy. It's a grant after all, and a grant is not a loan. A grant is a given, right? And there's a part of that law that also says it's going to be forgiven. So all I'm saying is that it's a part of the law that is not black and white, and that we need to consider where you file your bankruptcy or where your debtor is filing for bankruptcy, understand if they have applied for those grants, and how will our judge treat those grants in bankruptcy. So you need to have an attorney to be able to speak with them about that. Okay? All right, moving on. So basically, I explained that subchapter 5, you put all of your disposable income, that means after expenses, you're able to modify your mortgages, you're able to strip them off completely if necessary. You do get a discharge after 5 years completion, and there's no claims, no soliciting, or no voting. That's something for you to take home. So I gave you like a synopsis if you're a little bit confused of one chapter versus another and what's the good one and what's the bad one. I'm giving you a synopsis of the difference for us, not for attorneys and all their mumbo jumbo language, but for us, for you to take home and say, okay, what do I want to do? Subchapter 5 under a chapter 11 has a trustee in all the cases, does provide a planned deadline. In other words, there's no exclusivity period. Only the debtor files for the plan versus having a creditor be able to file on their behalf. There's cramdown rules, meaning that you can modify mortgages and you can strip off mortgages. And there's a discharge, which is really dependent on whether that plan was consented or crammed down. Another thing I want you to take home is the fact that that under a chapter 11, there are things like pre-negotiations or pre-packaged plans. They're beautiful. They're all it. I love them. And it really pretty much means that you're bringing the creditors and the debtors together prior to the filing of the bankruptcy. And prior to that bankruptcy, you talk to them about what you intend to do once you file the bankruptcy. And you get them to sign and agree that this is what they're going to accept. And that is a beautiful part of a Chapter 11 case, because it allows you to create, by the way, GM Motors and a lot of big companies like Toys R Us, that's really pretty much what they did. They pre-negotiate, and then they submit it to the court and say, hey, court, I have something. It's going to work. We've already spoken to the most important people in our world, and this is what they have decided to do with us. So this is going to run smoothly, and it's going to work. And you avoid a lot of litigation in Chapter 11 cases if that's the route you want to take. All right? Moving on. We talk about out of court. So let's say that you don't want to do a bankruptcy at this point. You can negotiate. There's ways to do it. For example, cannabis business, marijuana businesses. You have a medical marijuana business, for example. Well, guess what? It's allowed under Florida. It's allowed in Colorado. It's allowed in California. It's allowed in Canada. But if you file for bankruptcy, it's not allowed. It's illicit money. And because it's illicit money, the bankruptcy would be kicked out. And if that's your situation, then bankruptcy wouldn't be an option for you. But you can still try to do a receiver, or you can still do what is called an assignment for the benefit of creditors. ABCs and receiverships are pretty much the standard right now to do out of bankruptcy when you want to be able to renegotiate your debt and not file for bankruptcy, and you do have the funds to be able to survive. If you don't, then you do need to talk about closing your doors and starting over again. All right. Last is the Chapter 12, which is the farmers and fishermen that I talked to you about. When you talk about subchapter 5, that we are encouraging you to entertain if this is something that you want to do in the future, or that you know someone that wants to do in the future. Only know that subchapter 5 pulls from Chapter 12 cases, which means that you don't have to be all business in order to file. You can be 50% business and you're still able to file your Chapter 5. Another difference that I wanted you to understand is that we're talking about 50% debt and not 50% income, which is very, very important because it's the debt that we're considering. You can be a solvent person, a solvent individual, and file, or a solvent entity and file your Chapter 11, Chapter 5. Ancillary, like I explained to you, so you have your Spain bankruptcy. You want to file in the United States because there's some assets here that you need to administer. You're going to have your foreign representative. The court is going to recognize that foreign representative, which is in and of itself a hearing. If there's other creditors that will want to fight it, they may. That's where everything comes in from Spain. It can be done by phone. The court authorizes it, and it's all about comity. And comity pretty much means that courtesy that we have between states and sovereign states, and the fact that whatever happens in Spain, we must respect, and whatever happens in the United States, we must respect. And we follow what the Spain bankruptcy is going through, and then we make determinations here. For example, can be on licenses agreements. You can have a licensor and a licensee, but if the licensee is in the United States, do be aware that the licensee under bankruptcy code has certain protections that maybe the Spain law will not have. So those are things that you may want to consider. The last things I want to talk to you before I give it to Rubén is the lien avoidance and the Cramdowns. I wanted you to understand the difference in things that can be done, that can happen in bankruptcy, which is, say you have a judgment and the judgment has been attached to an exempt property. Like, for example, you're a realtor and the realtor business is going bad. You receive a judgment, and then for X or Y reason, they went ahead and did attached a judgment lien into your homestead. Well, in that bankruptcy, you will be able to completely knock it down and completely wipe out that judgment lien. The Cramdowns, which I explained to you, it's trying to modify the mortgage and pay less. Sometimes you pay less by the interest rate, taking it down to 4 or 5%, if it was a 7 or 8 or a 9 or an 18. Or you can extend the maturity date. You can also try to agree to capitalize the principal, or you can simply devalue it. Say that it is a real estate that you have, and the real estate has been, the mortgage is $525,000, and right now the value of the real estate due to coronavirus it's down to $125,000. Yes, you can cram it down to the value of the building and knock out $400,000. That's what would happen in this type of situation. Let's say that you have a second mortgage in that building. That second mortgage due to that value would get zero. It's a strip off. Yes, you can do that in bankruptcy. Okay. And then the leases. The leases basically have 3 type of opportunities. I've talked about them since the very beginning, and I'm going to tell you one more time, which is you can assume a lease, which means I'm going to stay with this lease. Say you're, again, the tenant in a mall, in the mall, and you want to continue in that particular location. That's the location that gives you the business. In fact, you may have 2. That's even better. So you have 2 leases, and under one mall, you're doing really bad. But under this mall, you're doing really good. Then this is where you take advantage and you assume the lease of the shopping mall that is producing the monetary funding, but you reject the other one. And yes, you can do it in bankruptcy. Or let's say even better, you want to stay with both. This is something that bankruptcy is a beautiful thing. It's really called a fresh start for a reason. So let's say that you have 2, you want to stay with the 2 stores, right? But one, you are assuming that responsibility, but you have your cousin that is willing to partner with you, is willing to put a little bit of money into it, and is willing to assume that second lease. Then you're able to assume and assign to your cousin. Those are things that can be done. And like I said, if you don't want it, you don't want it, and you're rejected. What you don't want to do is assume it, and then after a year say, bad deal, let's reject it. I can do that too for you. But when you do that, the creditor is entitled to, it's called an administrative claim, which is entitled to a particular amount of money that is actually required to be paid prior to rejection. So it's going to cost you money is all I want to say. And sometimes you don't have that money. You're trying to restructure. So you want to be very sure what you want to do at the moment that you're filing and planning and creating that payment plan. All right? That's pretty much it. I wanted to let you know that you can mediate in bankruptcy. So there's a lot of times that just nothing works, right? There's times that you just want to fight and fight and fight and fight and nothing works. And guess what? Mediation works. Mediation is encouraged by the judges. You, whether you're a creditor or a debtor, are looked upon in good eyes because you're trying to resolve, okay? And guess what? Mediation works. A lot of times it's getting through the barriers that allows the renegotiation. And sometimes that third party is all you need, that will calm the parties down, that will be more objective on how the relationship can continue. So mediation works. Mediation is in bankruptcy. Mediation abounds, and is successful in itself. That's pretty much it for me. I don't know if I have answered all your questions, but we do have a questions afterwards. So do stay with me so you can learn a little bit about Spain. And once we do that, I don't know about the time. Rubén, all for you. And this is me. You can email me at Shirley Palumbo at GM Law. Thank you very much. Me pasé.
Rubén, you're muted.
Yeah. Empieza.
Okay. Good morning, good afternoon. Thank you very much to the attendees for being with us. I cannot tell you that I'm going to do it so as Shirley did, because it's impressive. No, the presentation was impressive, and she told us many things about the US cases and the US processes. And to be honest, I cannot tell you we have that kind of processes in Spain, and therefore you cannot spend, you cannot wait. Okay, I'm going to see the kind of Chapter 11 or we have similar Chapter 7. In case of Chapter 11, we have something very close to that, which is Acuerdo de Refinanciación, and we have even some kind of sub-Chapter 5 under Chapter 11, which is very close, and we have no specialized process for farmers or fishers, but we have for soccer clubs or sport clubs, this kind of special processes we have in Spain. I want just to share my screen with you, but I can see only my, there's a possible, okay, thank you very much. Okay. I just want to remember we are a law firm, then we have accountants in the same firm, and then we offer this kind of services as trustees, as solicitors or lawyers, and in several jurisdictions in Europe, in United Kingdom, and in Spain, and we have all these kind of issues in several countries. Okay, you must, I'm not going to repeat some concepts, some very issues that Shirley already explained you, and perfectly explained, is wonderful, no? Such as the debtor, creditor, financial creditor, Cramdown, and all of these concepts, because it fly perfectly well to Spain. You can say in Spain, in a kind of bank, you will find the debtor, you will find sometimes the debtor in possession or not in possession, you will find the creditors, financial creditor, labor creditors, commercial ones, and the public ones, the public creditor, which is usually the internal revenue departments. And at the same time, you can find some kind of cram down in the Acuerdo Refinanciación, which is the similar process we have in Spain for Chapter 11. Even when we amend our insolvency law back to 2014, I think we used this example of the bankrupt code and not the scheme of arrangement. Many people think that in Spain we amend our insolvency law based on the scheme of arrangement coming from, but it was not the real issue. We use as an example the Chapter 11. Then I'm not going to repeat use some concepts Shirley has already explained you, and because I have to save time. Spain is a member state of the European Union. As you know, there are some laws in European Union compulsory in the member state, and this is the rules. And then we have one specialized on insolvency cases when these insolvency states has affiliate companies or just assets in other member states. Imagine you are a Spanish company and you have assets in Portugal, France, United Kingdom for now, not at the end of the year, Germany. Okay, then you can file for this process in Spain as main process, and then you can open several processes around European Union member states just because you have some companies as independent companies, affiliate companies, or just because you have some assets. You can apply this one to individuals. At the same time, individuals has their own main address in Spain, but they have a second home in Italy or in France. Then you can apply. I'm going to focus on the out of the process in Spain. Why? Because I think that now, because of the coronavirus, we are under big stress in the country. And then taking into account that we forecast thousands of cases filing for insolvency at the commercial courts, and even more cases filing for individual insolvencies at juzgados de primera instancia, which is not the commercial code, but a normal one, we are going to focus in out of the code processes. And even based on what Shirley told you, I can tell you, okay, we are going to look for a Chapter 11, and we are going to look for a sub-Chapter 5 under Chapter 11, which is both out of the code process. You can, you have in the Spanish regulation, the Spanish insolvency law. One of them is Acuerdo Extrajudicial de Pagos. Most of you can speak Spanish, then I have no problem to use some Spanish word. But this is a kind of a small, if you Shirley Palumbo presentation, you can find that there's a kind of sub-Chapter 5 and the Chapter 11 for small businesses, even for individuals. In case of Spain, it's for individuals, yes, they are not businessmen, or individuals, they are businessmen, or just for small and medium-sized companies having less than 5 million euros, which is almost 5.5 million US dollars, you can try to use this process. And this process starts up with a kind of mediation. You apply You go just to your district notary, and you apply them just to appoint you a kind of mediador, okay? They will look and they will try to find one who accepts this appointment. To be honest, it's very difficult because the fees for the appointment of a mediator is really low, and most of them refuse to accept this kind of cases. But if you try, you will find one, and then they will try to start up just calling the creditors. Yes, the mediator will ask the debtor, how much are the debts you have? Can you show me the debts, the debts detail of your creditors? And then just to try to figure out the liabilities of your state. And once they have done, they will send to these creditors just to call them for a creditor meeting. The creditors can attend this meeting, can refuse to attend the meeting and say, okay, I vote against that. Yes, and then I will not attend, but they must to answer the call if you want, because in case they don't, they can be the priority in the states can be go under just because they didn't answer, even they didn't attend. Most of the cases they refuse to attend, or just they vote against the payments proposal, the payments plan. Okay, but any case it works such a way, and it starts and on this way. Once you have called for the creditors meeting, the mediator will try to find the way the debtor and his creditor, her creditors will find a kind of deal, a kind of agreement to pay them. Can be in 5 years with some cuts, not more usually than 25% of the amount. Even you can cut whatever you want, but then maybe you will not find the support of the credit. You must to try to convince them to support your plan. It's not a kind of business plan, it's a payments plan. If you're a company, small and medium-sized business plan. Okay, if you are enough to reach an agreement with your creditors, then you have to go to the public notary, and then you have to sign the deed, a kind of deed of the plans, so that all the creditors who support this plan, must be a majority of them, sign that. Once you have the deed, you must to file this deed at the court of your district, and then it's approved. And then you must to fulfill this plan and pay on the terms you establish on the plan. To be honest, most of the cases, this kind of process end filing for a consecutive liquidation of the assets of the small and medium-sized companies, or just the businessman as individual, or just the individual as consumer, because creditor refuse, financial creditors refuse to sit on a table to reach an agreement. It's not compulsory for public creditors, which means that in case of small and medium-sized companies, it doesn't work, because the composition of the liabilities of usual small and medium-sized enterprise is based 30%, 25, 40% on public debts. Then these creditors are really extremely important to achieve this kind of payment plans. That's the reason, because of this mediation process, to try to settle a kind of agreement with your creditors, be success, and then you must file for a liquidation at the commercial court in case of businessmen or small and medium-sized enterprises, companies. All in case of the individuals, not being businessmen or companies, you file for insolvency at the juzgado de primera instancia, which is a normal court, which will deal with that and not in a short time. But it's something you have there. You must to try. I advise you, in case you are an individual, in case you are a businessman, in case you are a small and medium-sized company, to try to reach this kind of agreement. Maybe you are successful enough, because in case of the public creditors, you can reach a kind of agreement just dealing with their debts, because you can deal with the commercial creditors, yes, usually suppliers. You can deal with the financial institution in case they want to sit with you and they are more open-minded every day. And in case of the public bodies, you can reach an agreement to pay them in 5 years without cuts. They never accept cuts, but you can extend the payments and you can reach a kind of payments plan, so you can, having both sides on the table, you can achieve this kind of payment plans. This is for small and medium-sized companies and businessmen and consumers. Then it's more simply the same, because sub-chapter 11, businessmen and small and medium-sized companies, not more than 7.5 million US dollars, in Spain 5.5. But nowadays, because of the new insolvency law the government has approved some weeks ago, and it's going to be up September the 1st, these debts are not limited. Then it gives you maybe some chances to reach an agreement. Even in case that you cannot reach this kind of agreement, you cannot settle this agreement with your creditors, maybe you can apply for convenio anticipado, which is a kind of voluntary agreement, but it must be achieved and approved once you are in a process of a formal court process solvency. Therefore, is not same than acuerdo extrajudicial de pagos, this out of the court agreement, because you must file for insolvency. Once you are in insolvency, the court will approve your agreement to the creditors. It gives you the chance to approve just with 51% of the non-secure creditors, because the secure creditors usually has the rights on their assets. It's a kind of mortgage on a real estate. Then I will choose the real estate, or just to have a lease in case that you are going to continue trading. Then okay, I stay with my mortgage, you pay my mortgage, and then you can reach the agreement with your non-secure creditors. And once you have the majority, it can be approved. Even in a formal court process, you can prove another kind of convenio settlement with your creditors. The Chapter 11, typical Chapter 11 of Spain, Acuerdo de Refinanciación, is very similar to the Chapter 11 in US. The debtor is in possession, there's no trustee for now. Once we have to approve the European directive, and then we translate this European directive in a kind of, we have the term July 2021 or July 2022. If we apply for an extension, then we must appoint a trustee. But for now, the debtor is in possession. You can file for this kind of stop individual enforcements just with one letter. very easy. Court, I'm going to deal with my financial creditors to try to achieve restructuring financial plan, we can call that. And I'm not going to deal with the normal, with the commercial creditor, with the suppliers, or even with the public ones, the public creditors, or the employees, because I'm going to pay them on time, or even I will take some days later, but why? Because usually this kind of financial restructuring plans are applicable to big companies. It's not for small companies. Even if it can use by anyone, it's not forbidden if you are in a small company to try to achieve this kind of agreement. But to be honest, it's very difficult because usually it's for medium and big side companies because they have enough amount of financial debts, their financial creditors. In the Spanish law, you have labor creditors, employees, public ones, public bodies such as Internal Revenue Department or Social Security. You have ones which is usually the suppliers and the financial institution. Financial, this kind of Chapter 11, if you want to call it that way, is usually dealing with institutions, and it can cram down the dissident financial creditors in case you have the majority. If you achieve the majority of 75%, you can cram down them. You have these 3 months. When you have filed for the moratorium, stop of individual enforcement related with the business, you have 3 months, 12 weeks to deal with your creditors and to try to achieve the financial restructuring plan to approve. If it, and even it depends on what you want to do, you have more or less majority. If you just want to apply for an extension of payments, no cuts, no debt equity swap, then you are not going to capitalize debts, or you are not going to apply for a change of financial conditions more than the normal ones, then you just need to have the majority, and then you can approve it if you have enough majority, 51%. If you apply for more than an extension of 5 years, even I want to cut 20% of the financial creditors' debts, I just want to extend the, even realize some assets, then you need an upper majority. Most of the cases, they look for 75% of support of the finance to be approved, because once you are dealing with that kind of process and you are protected of the individual enforcement, financial creditors can start, you are going to look for schedule of your financial debts. Is really important for all the people. Then you are going to apply maybe for a cut, for extension, for a capitalize of debts, a debt equity swap, for new financial conditions, and any other things you want to do. But you must to convince your financial creditor, at least for the majority, you are going to need to approve the plan, 75% in that case of so many changes of the financial creditor debts. Once you have achieved this agreement, you have the support of your financial creditors, it's really easy. You just apply to the court with the report of your auditor telling the judge, okay, they have the majority. I stamp, I sign the report. This is the total amount of the financial debts. These are the financial creditors, and those financial creditors support the plan, vote in favor of the approval of this plan, and then they have achieved the majority of 75% of the financial creditors. And there's no sacrifice. This is the, and it was a main issue some years ago, 3-4 years ago, once the some descendant financial creditors applied the code not to a restructuring financial plan, even the debtor have achieved the majority because they sacrificed in favor of the debtor, in favor of the company. Most of the commercial courts use these applications, and now I can tell you that sacrifice is not an issue anymore for Spanish commercial courts. Then, if you have support of the financial creditors to your restructuring financial plan, you have 75%. Yes, the court will approve that, and you will start. Even with the new regulation of the government because of the coronavirus, all restructuring financial plans already approved by commercial courts, and if they cannot achieve the goals, they cannot achieve the due terms of the debts, they cannot pay in the due term, you can even now apply for reschedule for a new financial plan. Of course, you must deal this financial restructuring financial plan with your financial creditors again, because of the coronavirus. Many are nowadays under threat, and they must reschedule the terms of the payments. Usually, you with your financial institutions and you can achieve a new one. But if some of financial institution which accepted your restructuring financial plan refused now to deal with a new one, they will not be accepted sorry liquidation until March the 14th of 2021. That means that the new regulation of special circumstances under the threat of the coronavirus allow debtor to try to reschedule the financial plans because they are under stress, cash flows stress, or they cannot achieve the terms they approved before. It happens same with acuerdos extrajudiciales de pagos, with the kind of agreement for small and medium-sized companies. It's not common, but it's exactly the same, and even it applies for the agreement with the creditors in courts, because we have already spoken about the out-of-the-court processes to approve a restructuring financial plan with your creditors, financial for big companies, Chapter 11, and the small ones, Chapter 5, and the Chapter 11 U.S. bankruptcy law. But in that case, in the Spanish insolvency law. But imagine you cannot achieve this kind of deal with your creditors. Then you file for insolvency, and once you are in the court, in the formal court insolvency process, you can even try to achieve a deal with your creditors, but then you will address the unsecured creditors, secure mortgage and all types of guarantees on assets or shares, real estate asset, this kind of issues. They will prefer not to be engaged in this kind of agreement, or even just to be engaged in case they need to be engaged, or the public debts, the public creditors will refuse to be engaged. For the part of the debt, they have preference, but you deal with your unsecured creditors, and if you have enough majority, you can even approve it. It's a plan, payments plan. If not, you go into liquidation. But once you are in the court, in the formal court process, the court will appoint a trustee, and you will be overseen by a trustee, administrador concursal, and they will, even you can be a debtor in possession, but they will oversee your activities and must sign all payments or deposition, realization of assets, or any kind of selling or just buying assets. Or even if you want to lay off employees, if you want to make some employees redundant, you need to be approved by the trustee. And once you are in a liquidation, then you are not anymore a debtor in possession. The trustee administrate the company because they have to realize the assets at the best price to collect the money to pay the creditors. Then is the role of the trustee has changed. If you are in a formal process of insolvency in a court at the beginning, you are a debtor in possession. If you didn't apply, you can apply for liquidation. But once you are in liquidation, then you will be not the administrator of the state, of the company, because this company is going to be closed, the assets will be realized, the trustee will collect the money, and with that money will pay the creditors in order insolvency law regulate. This is the most of the court in court Spanish process. Of course, it affects contracts, it can affect employees, it can affect lease. Of course, you can retain a lease or reject the lease. If you are going to liquidate the company or just to liquidate some units of the company. Imagine a company, they have 3 location in 3 malls, and then you have 3 shops. And then you say, okay, one shop is really profitable, then I want to retain that. 2 shops are really just losing money, and I want to close this. You can do it. Even you say, okay, I cannot, or I just to refuse to be the administrator of the company, but the trustee overseeing the case see, okay, I want to maintain open trading as ongoing this business because it's a profitable business. The shop of the mall is profitable, and then I will get more money as ongoing concern that liquidation of this unit of the company. You can do it. Trustee can do it, can sell this unit of the company, collect the money for the state, and then close the 2 shops. And of course, some employees are redundant, no problem at all. They can do it. Of course, they must to deal with the employees' representation and so on, collect the money, and even in case that the state cannot pay redundancy payments of employees, there's a kind of insurance, public insurance will take care of the redundancy payments of these employees. Of course, they have a kind of cap, no more than that amount of money per month, no more at any case of 25,000 US dollars for salaries and redundancy payments, but you have a kind of insurance for employees. And then it facilitates the trustee to deal with the trade unions for closing the business, just telling them, I have not enough money in cash, but any case you will receive the money for the public insurance. And once I have realized the assets and I will collect the money, I will take into account you or the insurance company if the insurance company have already paid your redundancy payments because you were laid off, you were redundant of the company. There are many kind of mix between all of these questions. To be honest, in Spain, in Europe in general, is not the same image you can find in US, because in US the culture of entrepreneurial and even they don't look so bad. The people who need to apply for bankruptcies. Nowadays in Spain, after the crisis, the first one to 2008, 2012, okay, the people accept that many businessmen has no, they were not, they did anything bad because they apply for bankruptcy, for insolvency. It was just the circumstances of the economy. Then I must to file for insolvency, for bankruptcy. Nowadays, therefore, the image is not so bad as before. But I cannot tell you that the people looks at this process the same than in US as a second chance, fresh start. It's not the case, but any case we have done a long way. If we look back of the big first crisis to those days to nowadays, with under the threat of the coronavirus crisis. Therefore, if a businessman need to file for insolvency, need to try to deal with their creditors because of the new circumstances, or a big company need to deal with their financial institution in Chapter 11, I think that is really common. Another point that I don't want to forget is that in Chapter 11, you can apply at the core not to be disclosed. Then it's a kind of non-disclosed agreement among financial creditors and the financial consultants and lawyers, okay? Then all of them are sitting on the table, but nobody knows about that. Even once you apply for the recognition of this agreement at the court, you are protecting this settlement, this agreement, this contract from the juridical point of view, from clawback action of other descendant creditors. Imagine you have the 76% of the 84% of the financial refuse to support your restructuring financial plan, and then you cram down then, which means I approve any case, even you oppose to my plan because you are 24%. Even they apply for sacrifice at the court, they claim the court refused that. Okay, then you are protecting this contract in case that this company, after 2 years, files for insolvency. It's really important once you have to give some assets of your companies or even other assets because of the contract, the agreement you deal and you achieve with your financial creditors. Then once the commercial courts recognize the settlement is protected of clawback actions of dissidents or in the future, not just now for Cramdown, but in the future, in the matter, the company would need to file for insolvency, and the future trustee in 2024 will try to threat this agreement, you are protected. You are protected because the core, of course, you are not protected of everything. I'm not going to speak you about the wrongful trading preference or misfires or some, of course, bad behaviors directors can have managing a company, but you are protected of the good faith financial creditors who achieve this agreement, extend the terms of the financial of the loans, accept, collect some, realize some asset or wherever. So I just want to say you, just 3 minutes for the Spanish government measure against coronavirus. There's short-term unemployment benefits. If a company cannot, this is something in US they call job schemes, job retention payment, PPP. We have that in Spain. You can apply for some employees, for all employees. You can apply for some employees 40, 50%, 60%. These employees is going to continue working, or even I closed my restaurant, I did it because of the law, then it's force majeure. That means that I can put all my employees 100% under this scheme, and the government will pay them not exactly the same salary, but yes, you can defer your tax payments if you have to pay your income tax retention of employees. You can defer. You can defer some months until the end of May, or even you can apply without guarantee with a maximum of 30,000 is for small and medium-sized companies, for a kind of extension of 6 months for payment. Even you can apply for longer extensions, but then maybe they will refuse that, or they will ask you for some guarantees or whatever. Same with Social Security. There's many regulation for families under threats. You can't stop to pay mortgage because you are a family and then you were laid off of your company and you are a mother, you have 2 children. They can not enforce the mortgage for 13 months. They will provide you some kind of loan to pay your mortgage. If you are under a lease and you must to pay the rent to your landlord because you are a tenant, you can apply for the same situation. There's always in Spain a kind of income guarantee of the government. They are going to improve this income guarantee for the under threat people, if you can call them people under the income law. The incomes you need to survive in Spain, maybe it's $800, 1,000. It depends on the family personal circumstances. It's applied to this kind of electricity bill, internet bill, water supply, gas supply in cases, you know that Spain is the same than in US, not in of US is really cold. Happens in Spain, some part of the country are really warm, other not. Then the gas can become a kind of essential need. You can apply for that. And if you collect off this kind of social measures together, maybe it's too much, maybe it's too less. It depends who are you going to ask for. But any case, it's there. Of course, as Shirley told you, you always, you can call your creditors, you can sit on a table on a good faith and try to achieve a kind of agreement. Even in very complex cases, you can sign in a kind of standstill. It's like, okay, we all of us sit on that table and try to reach a kind of agreement, to achieve a kind of agreement for surviving this company, because this company wants trading. You can do it. You can try to do it. Maybe you are success, not success, but this is something it exists. And even in case that you are a consumer, you cannot pay your debts, and at the end you say, okay, I cannot pay anymore my debts because of these new circumstances, or even because I have some problems with something. Okay, you can apply even for a discharge, which is very important for families, for a second chance, for a refresh. You can apply. You must to apply. You must to file for individual insolvency, but you have no assets to realize, and you have the debts, and you are unemployment. You have less income than certain amount of money. You can apply. I cannot tell you it's going to be very fast. Sometimes yes, months, weeks. Sometimes the court is so collapsed they cannot manage it properly, and that means it takes more time than it needs. You can do it any case. And that's all I want to say you today. Thank you very much for being there. And if you want to ask some question, I think that Shirley and me will be more than delighted to answer. Of course, I told you at the beginning, my presentation is not going to be so exciting as this. Play not the good tools bankrupt code give to the practitioner in US. I must to be honest. Thank you very much. Yes,
Hi.
questions or?
Yeah, Rubén, we received some questions. So here they say there have been changes in the Spanish bankruptcy law as a consequence of COVID-19 and in the US legislation. There have been changes in the Spanish bankruptcy. Oh, okay. That's the question. There have been changes in the Spanish bankruptcy law as a consequence of COVID-19 and in the USA legislation.
Yes,
I'm
in
going
the
to try
United
to be
States.
very. Yes, in
Okay.
Spain, just for members meeting to approve the annual accounts, just for applying for insolvency, just to stop the compulsory insolvency applicators to say no, not for now, just for, as I told you, reschedule of the financial plans, yes, and for taxes, social security, as I explained. Just to be very brief.
Okay.
And in the
So,
United States, yes. The specifically what I explained up to Chapter 5, the small businesses, in order to file bankruptcy, it's usually, or since February and the law was enacted, was $2,500,000 debt in order to file or less. And now it has been extended to $7,500,000. So if you have $7,500,000 in debt or less, you can file a small business type of bankruptcy. So it was expanded. The other part, it's more for consumer type of bankruptcy and not for businesses, where usually that type of bankruptcy can last 5 years. And due to coronavirus, they have expanded a plan arrangement of 7 years. So now you can file it for 7 years. That's pretty much it. Apart from that, outside of the insolvency laws, there's been a lot of changes like moratoriums and foreclosures and forbearances. A lot of, even at custom controls of masks. There's been a lot of changes everywhere in all sorts of law. But for insolvency, the consumer got protected by expanding the plan to 7 years, and the businesses got protected by increasing the debt eligibility to be able to file. Okay.
Okay, thank you. We have here another question. Can a tenant file for bankruptcy and still stay in a residential home?
Yes. Rubén, for you? In my world, in the United States, yes.
Yes, yes, too, as well, yes.
Yes.
Okay.
So the answer is yes, you can stay.
Here we have one in Spanish. Me gustaría saber si la legislación concursal es la misma en todo Estados Unidos o varía en cada estado.
Buena pregunta. ¿La contesto en español?
As you wish.
La contestación, la contestación es sí y no, porque acuérdate que en Estados Unidos somos muchos estados con muchos distritos y entonces está la ley federal. La ley federal protege y es la misma ley, es el mismo código a donde quiera que vayamos. Y donde quiera que vayamos, todo lo que yo hablé hoy aplica. No va a tener ningún problema. Pero cada estado va a tener alguna que otra cosita un poquitito diferente, pero sí aplica la protección en general y es completa.
Okay. We have some other questions, but we are running out of time. So if someone wants to ask these questions, we'll send the contact information of Rubén and Shirley so they can answer them. And well, thank you very much, Rubén and Shirley, for joining us today and talking about bankruptcy. It's been a pleasure being with you. And as I mentioned today, we will share the presentation with the follow-up email and the video of this session. And
Okay.
well, thank you very much. If you want to learn more about the webinars of the Spain-US Chamber of Commerce, you can find them on our website that you will find in the chat section on your right panel.
Okay.
Okay, thank you very much. Good morning and good evening for Spain. Muchas gracias.
Gracias a ustedes. Encantada.
Bye.
Hasta luego.
Encantado.
Bye.
Bye bye.